Please be seated. Welcome to the First Court of Appeals. My name is Gordon Goodman, and on my left is Justice Hightower, and on my right is Justice Landau. We're here to hear the case of Alan Davis, John Mahoney, and the Mahoney Group LLP, and Michael Foulard versus MSR Holding LLC and Merrick Medical Finance LLC, case number 01-22-00451-CV. And I understand that appearing for Mr. Davis and Mr. Mahoney is Mr. Renshaw.
Yes.
And I understand you'll be speaking for 8 minutes and reserving 2 minutes, is that correct?
Yes, sir.
Okay. And appearing for Mr. Foulard is Mr. Merrill.
Yes, Your Honor.
And you will also be talking for 8 minutes and reserving 2.
Yes, Your Honor.
Okay, very good. And then finally appearing for the appellee is Mr. Whelan. Whelan. And you have 20 minutes also. So we'll start with Mr. Renshaw. That's all right?
Before I get on the clock, there's a...
Before you get started, we have a question.
Yeah, there's a Exhibit 201 that we couldn't find in the record. And could y'all find that exhibit and maybe agree to furnish it to the clerk's office, district clerk, and then furnish it to us?
Yes, Your Honor. Well, this is Plaintiff's Exhibit 201?
Yes.
Yes.
there was another housekeeping matter.
Go ahead.
The Mahoney Group is the Mahoney Group LLC, and for some reason the court has it as LLP.
Oh, okay. We'll correct that.
Minor issue.
Thank you.
Good afternoon, Your Honors, and may it please the court. This case is essentially about a man who went to the proverbial craps table, bet on the come, and lost. And now he's trying to blame the house and everyone in it. Nothing was hidden from him. The game was not rigged. And he knew and acknowledged the risks that he could lose it all before he ultimately decided to roll the dice. And in his friend's words, steal some equity in this company. The trial court committed errors of both fact and law in finding for the appellees. The Court of Appeals should reverse and render accordingly. 3 months prior to the investment at issue in this case, appellee MSR Holdings principal, Mr. Perry Rickle, signed a confidentiality agreement acknowledging that Iomnis was making no implied or expressed warranties or representations as to the accuracy or completeness of any of the information that was provided in conjunction with the prospective investment that Mr. Rickle and his company made. That's, do I need to make record references? I mean, I can. But in any event, after being provided everything Mr. Rickle asked for, nothing was orally and in writing, and knowing that the investment was not based upon Iomnis's then present financial condition, it was admittedly and acknowledged, everybody knew it was a distressed company.
We have to look at, though, were there any material misrepresentations or omissions? And was there any information provided that, for example, money was going to be used immediately from his contribution to pay off some of the people that were members of the group?
There were no restrictions. No, there were no restrictions placed on the investment. Mr. Rickle is a sophisticated investor. If he had wanted those restrictions, he could have asked for them. But there were no restrictions. There were no representations made about how the funds were going to be used. There were no restrictions on how those funds were going to be used. And admittedly, the company was distressed. The financials that Mr. Rickle and his colleagues, I guess, were provided clearly showed that it was not anything other than an investment in a very, very distressed company that Mr. Rickle knew from the outset had high upside potential.
What about the concern about insolvency? I know MSR experts testified in that regard that the company actually was insolvent.
That was an issue at trial. The actual offering documents and the membership purchase and sale agreement made a representation that there was a conjunctive issue, you know, that the company was not insolvent and subject to insolvency proceedings, bankruptcy, or anything else on the claims of creditors. And on top of that, the company continued in operations through the time of trial and even beyond, I believe. I can't remember exactly when the company ultimately forfeited its existence, but they were limping along as best as they could under the circumstances, and there were no representations regarding insolvency in and of itself. So when MSR was founded by Mr. Rickel for the purposes of this investment as a holding company, and when MSR agreed to bet on the comp, it entered into the membership interest and purchase and sale agreement that again acknowledged the risks of the investment and again made no guarantees of any profitability. So the totality of the evidence, without a doubt, showed that Mr. Rickel and his company were never concerned with the then existing financial condition of Iomnis. Everything was looking to the potential in the future, which everyone knew was uncertain, but also made known to Mr. Rickel and MSR and acknowledged by him before his investment, during the due diligence process, and again and last in the membership interest purchase and sale agreement. There is not one affirmative misrepresentation of facts, material or otherwise, nor are there any omissions of facts in the record in this case, both of which the Texas Securities Act requires before liability can be imposed under the Act.
I thought there was a discussion about the fact that there was a period of several months during which they were unable to buy inventory. And I think Mr. Rickles commented that obviously if you can't buy inventory, you can't sell inventory. That would have been material to him, but it was omitted from the representations.
One supplier had cut off, I think it was Dell Computers, had cut them off because they had an outstanding debt, and that was also known to Mr. Rickel and MSR. They had inventory.
That they had been cut off, or that there was debt?
I think both, but they had inventory. They had inventory in their possession, so it wasn't like they were an empty shell of a company just waiting for something to happen. There was inventory, and I believe actually even up until the time of trial. But in any event, there were no misrepresentations of any facts or omissions of any of these facts.
Mr. Renshaw, how do you categorize the lack of update about the Mexico City project? Davis knew that it would be delayed and updated the board but didn't update Rickel. Are you saying that is not an omission or it's not material?
Mr. Rickel was aware, and that's Mr. Rickel was aware that there was no contract for Mexico City.
Can you give me a record site for that one?
Yes.
That would help me
Yes.
greatly.
I apologize.
If you want, you can do that at rebuttal.
Okay, I will. I'm sorry.
Thank you.
I'm sorry, but I have it in my notes somewhere. It's just not in the order in which
I appreciate it.
So the totality of the evidence shows that they were never concerned with the then existing financial state of the company. They were fully, Mr. Rickel and MSR was fully made aware that this was a very distressed company, and that's exactly why he wanted to get in the first place. You know, we could use Enron as an analogy. You know, when Enron was at 39 cents a share, there were people still buying it, not knowing what was going to come. This is not an Enron situation, but still, people make calculated risks based upon information that's known to them. And in this case, everything was known to Mr. Rickel and MSR, which is exactly why he wanted to get in, for the tremendous upside potential that the Mexico City contract offered. And others as well, because Simon Malls at the Galleria, they were talking with them as well about putting in systems. Primary liability, as the court is surely aware, arises when a person offers to sell or sells a security by means of an untrue statement of material fact or an omission of material fact in the totality of the circumstances. And that is what we think that the trial court did not look at the totality of the circumstances. And the findings and conclusions reflect that.
Mr. Henshaw, your time is up. Did you have?
Oh, no, well, no, I'll just reserve for rebuttal.
Just one quick clarification I have. Did Mr. Mahoney become the COO of the company before or after the sale to MSR?
I don't believe that he was. He's never a member or he was a consultant.
He was never the COO? I don't know whose briefs it's in, but that's permeated throughout the briefs. And I
Mr.
was just trying
Davis.
to have some clarification. Maybe the other lawyers can comment on that, because it's in the briefing somewhere.
I don't believe it's in mine.
Okay.
But Mr. Mahoney and his company were neither members or managers or anything other than consultants for.
Mahoney wasn't an officer.
Correct.
Thank you, Mr. Henshaw. Mr. Merrill? And you're appearing for Mr. Foulard.
Yes, Your Honor. May it please the court, my name is James Merrow. Thank you very much for extending our time to 10 minutes. It's not much, but 2.5 minutes makes all the difference. I represent Appellant Mike Foulard. I'm going to get right to the point. The judgment against Mike should be reversed, and judgment should be rendered in his favor on all claims. In my very limited time, it's my expectation to talk about the TSA and secondary liability under the controlling person theory. We also have other claims, and I'm happy to address those if the court would like, or answer any questions. On control person, generally, there are two different paths this court can take to reverse the judgment and render judgment in Mike's favor. First, there is legally insufficient evidence that Mike was a controlling person of Iomnis. Second, Mike conclusively proved his defense that he did not know, and in the exercise of reasonable care could not have known about these alleged primary violations. Both of these paths lead to the same destination.
That's his affirmative defense, right?
It is, yes, Your Honor, it's described as a defense. I would probably say it's an affirmative defense, but I haven't found any case law on whether it's a defense or affirmative defense, but I would probably call it an affirmative defense. MSR's theory of controlling person is essentially based solely on a novel legal theory of theoretical influence. And I say theoretical influence because there's no evidence that Mike Foulard had actual influence. Legally and factually, this is not enough. Influence is not enough because the statute requires control, and factually, even if influence were enough, there's legally insufficient evidence that Mike actually had influence over these people.
As a Class A member, does Mr. Foulard, as a matter of law, have general control over the company?
He does not have general control over the company under the facts that we have here. The testimony, Your Honor, was that...
So that's fact-driven?
That is fact-driven, yes, Your Honor, because there were certain decisions that were reserved for the Class A members, there were certain that were reserved for the Class B, or the common members. So it is a factual inquiry, Your Honor. There are certain issues, however, that would be reserved for Class A members. I think the testimony from Mr. Davis was if there were a financial issue, he went to the Class A members because they were the ones providing all the money and loaning money. This is not a financial issue, however. This is an issue about membership and issuance of membership. And the testimony from Mr. Davis was as to membership and issuance of new units, that was controlled by the supermajority, which was George and Georgia. I want to get to this here.
Just for a moment.
Yes.
The influence that he had, Mr. Foulard had, was greater at the beginning of the endeavor and diminished over time?
I think the record does support that, Your Honor. I would say before the divorce that happens in 2013, Mike Foulard was the only Class A member. I think he had around 60%.
Right.
Now the divorce chopped that in half, and all of a sudden this acrimonious divorce leads to his wife, his ex-wife, holding half of those shares. Then after that, George, the estranged son, came in and purchased another 10%. So the record shows that certainly as of December 30th, 2014, when George is there to break the logjam between Mike and Georgia, Mike had no more influence anymore. In fact, the testimony then was Mr. Davis said he had usually gone to Mike for questions and consultation. After this, he all of a sudden went to what he called the supermajority. He referred to the supermajority throughout as George and which is Dynarock, George and Georgia. So, going to this test, the control over operations, the evidence is undisputed that Mike has never been involved in the day-to-day operations. And certainly less so, had less involvement even after the divorce and after George came in. Mr. Davis controlled all non-financial day-to-day management. The financial decisions went to George and Georgia. They went to the Class A members, but as Mr. Davis testified, he went to the supermajority instead. He stopped consulting with Mike. But again, this was not about a financial decision that would have gone to Class A. This was about the issuance of membership units. And Mr. Davis testified, first of all, the company agreement provides that everybody was to vote on issuance of new membership units. But specifically among Class A, Mr. Davis testified it was George and Georgia, the supermajority, that controlled that issue. I want to talk more specifically about the power to control this specific transaction, because that's where their theoretical influence argument seems to come in. It is undisputed that this sale was going to go through with or without Mike's vote. That's disputed in the evidence. Mr. Rickle admitted that. Mr. Davis specifically admitted that. As of July 28, 2015, every member except Mike had affirmatively voted to offer membership to Mr. Rickle. That was something like 80.63% of the interests, and a supermajority of the Class A interests.
Mr. Fouillard acknowledged that he signed a waiver that his ownership interest could be diminished. Wouldn't that be some kind of an evidentiary value of a vote if he is acknowledging that he knows his membership is going to be diminished because of this?
That's a good question, Your Honor. Because we don't have, I think the court's aware, we don't have direct evidence whether he voted. This would seem to suggest that after the fact, after this vote, he's at least gone along with it, right? He's at least gone along with the vote of the majority. Whether it indicates a vote, I don't know whether that's true, Your Honor.
And when did he know that he was going to receive a $20,000 payment for his own, towards his own debt?
I don't think that's clear in the record, Your Honor. I read through the record again last night, and I don't see a discussion about whether it was contemplated. I know that there was supposed to be a payment reschedule. That was according to Becky Claim's testimony, that there was a schedule. There was supposed to have been a payment back in June, I think, of 2015 that they didn't make. I don't think there's any evidence, Your Honor. I don't think it goes one way or the other about whether he knew when he was going to get a $20,000 payment was a loan repayment on his loan. Going back to Mr. Rickles and Mr. Davis's testimony, Mr. Rickle testified it was going to go through with or without Mike's vote, and it did not matter what Mike did. So their theory of control, again, is theoretical. Mr. Rickle said, well, if Mike could get a couple of other people to vote along with him. So this really boils down to a persuasiveness test, right? The test all of a sudden is, who's the most persuasive person in the room? I don't think that flies legally, but let's just deal with the facts. The facts are, nobody testified.
Mr. Morrow?
Yes, Your Honor.
Does it matter whether we use the Sandifer or the Frank test for the outcome? Does it come out the same way under either test?
Yes, Your Honor, it comes out the same way. We win either way. Sandifer would be it would be a one-paragraph opinion because there's no evidence of inducement or participation. We still won under Frank.
Sandifer's an easier test on you, correct?
It's an easier test for Mr. Fouillard, a harder test on the plaintiff, yes, Your Honor. Nobody testified that if Mike had stood up in this meeting of small number of investors and said that this was a bad idea, that anybody would have changed their mind, that anybody would have changed their vote. Mr. Mahoney didn't testify to that. Mr. Davis didn't testify to that. Mr. Rickle, who knew Mr. Fouillard after Mr. Rickle's investment, didn't testify to that. Nobody said that Mike could have made any difference there. What we have here is this suggestion that Mike was somehow going to have to convince more than one person to change their mind, and there's no evidence that he could actually do so. Nobody testified that Mike actually had the influence and the ability to get anybody to change their minds. The record shows exactly the opposite, including the fact that Mike was unable to stop everybody else in the company from allowing his ex-wife's divorce lawyer to buy shares in the company, even though Mike exercised his right of first refusal and offered more money. He just simply didn't have influence. There's no evidence of that, and all the evidence is to the contrary.
Thank you, Mr. Morrow. Any other questions? Mr. Whalen?
May it please the court. This is an appeal on a record that I don't recognize. The evidence in this record shows that Mr. Davis testified that Mr. Fouillard did vote. The court was entitled to believe that testimony. The evidence in the record.
I'm sorry, I didn't understand. Oh, that he voted.
That he
Okay.
did vote. The email that was sent indicates that he did vote. If I recall correctly, it says, "We have all voted to do the Perry deal." The "we have all voted" is there. Just to avoid what I know is coming is a specious argument concerning the sequence of the emails. The email does show a date and timestamp that the email "we have voted" supposedly happened before another email in the record, but that happened a number of times during, and was commented on during the testimony of Mr. Rickle concerning one of the emails. I believe it was Defendant's Exhibit 3 from Mr. Harrison to Mr. Rickle, and it basically, Mr. Rickle is asking the question. The answer comes according to the date stamps before the ask. That didn't happen. Mr. Rickle testified that it didn't happen, and it happened in this case. It happened again at this time. So the issue is whether there is some evidence in this record that he voted. To the extent that is a fact, the court is bound by the fact that the trial court found that there was evidence that he had voted.
Mr. Whalen, where is the record site on the information you're discussing right now?
Where is the record site?
What is the record site? If you have it.
The record site for the exhibits that it is a, which particular
You
document?
said that Mr. Foulard voted,
Yes.
and I want to know where in the record we would see that.
It's that record site is in our brief, specifically when it talks about Mr. Davis' testimony that Mr. Foulard voted.
But even if, let's just say, he did vote,
Yes.
he doesn't have a control interest on the Class A requirements, nor does he have a controlling number of percentages to control the member vote. So where does his control come in when he doesn't have the voting percentage or the Class A percentage to control the cell?
A couple of answers that are issues that we need to be unpacked. The test is not, and the appellants attempt to frame this as whether he had the authority to control unilaterally the vote is the test of whether or not he had control under the statute. It is not. At page 30 of Mr. Foulard's brief, he says something that I agree with profoundly. The issue of control depends on the circumstances. In this case, the issue is not just whether he had the decisive control over the vote. It is whether or not he had control or influence, according to the cases, under the statute. And he did have control or influence over the process. I think that the most important evidence that this court needs to look at is the cross-examination by Mr. Seckel of Mr. Foulard. It is at Records Volume 6, I think pages 113 through about 130. In that examination, Mr. Foulard first testifies, "I never got information about this deal." When then confronted with the emails that he denied he received, he said, "Well, I didn't read them." And then he said, "I didn't know what was in them because I gave them to Becky Clamp, and Becky Clamp was going to tell me what was in them if it were important."
Are we talking about before or after the sale?
This is all before the sale. These emails run in the emails, or in this part of the record, run from March February, March, before the sale. They run into July, and they deal specifically with the question of whether or not the company should seek outside investors to raise money. It is not a question solely about this contract and the vote of this contract. The question was presented to the board and to IONMS. What do? We don't have money. We can't pay our bills. Where do we get it?
Of course, Mr. Fouillard didn't have any conversations with Mr. Rickles prior to the sale, did he?
That does not matter one iota.
But the answer to my question is?
That is correct.
Okay.
And we have never argued that he did.
So do these emails describe what the court or what is alleged in the briefing to be the omissions and misrepresentations that were allegedly made from those conversations?
They discuss the facts on which those omissions are predicated.
So basically all they do is discuss the financial situation of the company?
No, they discuss not only the financial situation of the company, they discuss the fact that Dell, its only supplier of servers, the primary, if not almost exclusive source of the income, that they can't sell them because they don't have credit with their supplier. That fact, that material fact, was not disclosed. One other issue or one other concern is, it is all the facts and circumstances. There are two paths in this case for control. One is control over the agents of the company. That is vested exclusively in the board of managers. Many of the cases involve situations where not the companies who, in the control of the company that issues the securities is at stake. They involve cases where an underwriter is sued for the acts of a broker-dealer, or the broker-dealer is sued for the acts of its employees. In this case, Mr. Fouillard had influence. He was the founder, he was the chief financier, he remained a financier, and he had control and influence over what happened. They make a big deal out of the fact that he and his son cussed at one another when they had a phone call. As they said or to paraphrase or to reverse what they said in the Godfather, it was just personal, not business. There was no discussion and there was no testimony whatsoever that they discussed or disagreed about the business deal. It was simply that he and his wife, his ex-wife, and his son did not get along.
Was Mr. Fouillard the last to vote?
The order fallacy or the unilateral control fallacy are both fallacies. The question is, the issue of control is an issue that depends on the facts and circumstances. They agree, it's on page 30 of the brief, I agree. The facts and circumstances in this case show that Mr. Fouillard they reached out to him, but he ignored the information that he was provided. He admitted, and I think it's at page 129 of the transcript, that he abdicated completely his duties as a director or a member of the management team.
So you're saying he had a duty to influence the other two Class A members as well as the other voting member interest holders?
Under the company agreement, he had a duty to explicitly, in section 4, he had a duty to carefully examine the issues that came before the board of managers. He abdicated completely that responsibility. It cannot be the case that a statute, a remedial statute, that's created to protect investors can reward a director, a person on the board of managers, for abdicating completely his responsibility to care and to supervise employees, to monitor the solicitation of investments in his own company. That would turn the statute on its head. It would make the statute depend on gamesmanship. What can I do here? Let's see. I'm liable if I vote last. Or if I vote first, I'm not liable if I vote last. The evidence, the record in this case does not indicate that there was complete, that the two were always against it. There was one instance in this record where there was a dispute over business, and it wasn't about bringing in new money. They agreed they needed to bring in new money. It was about whose money they brought in. And to show how personal and not business related it was, Mr. Fullard said, I'll even contribute more money than my ex-wife's divorce lawyer, or I'll invest more money if she assigns a malpractice claim to me so that I can sue him. It had nothing whatsoever to do with the business of Iomnis. He wanted to use that, his personal pique, to, as he said, he relished the fact that he retained control. And that's probably the reason he didn't resign. He said, he asked the question, you could have resigned, couldn't you? No. Yes, I could. You didn't resign. He wanted to keep his rights. He wanted to keep his powers. But he didn't want to relinquish the control he had, because that's what allowed him to stick it to his ex-wife and his estranged son. That kind of conduct cannot excuse the complete and total failure, the complete abdication of his responsibility as a member of the board of managers to supervise employees. There is no question that Davis and Mahoney made misrepresentations. The evidence shows that the company was insolvent. The evidence shows that they represented in the MIPA that the company was insolvent.
Is there any evidence he knew of the misrepresentations before the sale?
Yeah, yes, and it's in the membership interest purchase agreement. The company is not insolvent on any basis. That is an express representation in the membership interest purchase agreement. The other statement is that the projections that were provided there was a reasonable basis for them, and there was not. In some of the issues, there was simply, Mr. Renshaw said, well, these were future-looking statements. They were not. There were statements that we have certain contracts, the documents, the financial statements or financial protections show that revenues from contracts that they represented they had and did not have would start on date certain and but they didn't have the contracts. They couldn't project it would start on the date certain. The series of financial statements and monthly reports, again, which the evidence shows were sent to Mr. Fullard. He denied it, but he contradicted himself. Again, the records 6, 113 through about 130 is critical reading. Look at those exhibits, look at that testimony, because it demonstrates that Mr. Fullard had the power, he had the knowledge, and if he didn't have the knowledge, it's because he ignored the information that was being provided to him. A person in his position could... Go ahead. I apologize. in his position, cannot abdicate and then claim that somehow by abdicating his duties but not relinquishing his rights, he is able to avoid control person liability under the statute. The cases are clear. The primary liability is not there's no scienter requirement. Whether or not the control person knew of the specific misrepresentations is not the test. It's whether or not they knew about the facts on which the liability is based, or had the opportunity to do so. The Fullard's counsel said they established their defense as a matter of law. Their defense is a matter of law. That test is, he did not know and in the exercise of reasonable diligence could not have known. There's no evidence to support that finding, or the trial court found to the contrary. And the evidence is pretty much undisputed out of Mr. Fullard's own mouth that he didn't do anything, and he ignored quite a bit.
Can I ask you a question about Mr. Mahoney?
Yes.
In some of the briefing and at trial, he's referred to as the COO, but I'm just trying to nail down in the record where he is referred to that way. Is that a shorthand? Was he not the COO?
He was the CEO. He came in, there's an email from Mr. Davis to the board, and he basically says, I'm bringing him on as the COO to help with operations.
Was that before or after the sale?
That was long before the sale. The Mahoney Group, by the way, is also a control person, and Mahoney is a control, or not a control person, is a seller. And this is one of the other things that is...
There's no distinctions between Mahoney and the company Mahoney. I mean, no separate defenses, no separate
defenses. Mr. Mahoney was the COO. Mahoney Group had a contract. Under that contract, it was supposed to get money, a percentage of the sale, because under the contract, he was supposed to go raise money. But one of the critical issues is the question of who are the controlled persons. The controlled persons are the seller. Who are the sellers in this case? The sellers are the company, because it transferred title, and it is Mahoney, Davis, and the Mahoney Group, because they had an economic interest, and they were motivated in part to solicit these funds for Iomnis or for their own economic interest. And it's an OR test. So there are 3-4 sellers, not just one. That means that the issues that Fullard ignores, the question of control by means other than, by means other than the vote, are relevant, they are material, and under the circumstances of this case, it is the failure to supervise the people that that company had and employed and authorized to go out and solicit new money, went and made serial and extreme misrepresentations of material facts. The primary liability is almost incontrovertible, but the issue with respect to Fullard is all of his positions depend upon a misreading or ignoring the facts in the record concerning what happened. He says, he characterizes, I'm out of time.
Do you have any more questions? Or? Thank you very much, Mr. Whaley. Mr. Renshaw, I think you have 2 minutes reserved.
Justice Landau, with respect to the reference to the record for the Mexico City contract, that's in page 6 of our brief, and it's in the record in volume 4. pages 182 to 188, and also 185. I wanted to hit on a couple of other points. Mr. Whalen keeps saying there's all these misrepresentations and all these omissions, but neither he nor the trial court said what those misrepresentations or omissions were. It's just sort of, there were misrepresentations. Okay, well, are we just supposed to guess what those were in light of the totality of the circumstances? There were omissions. Omissions of what? In the totality of the circumstances, we're all just left. What does that mean? The MOU we did not address. I did not address in my initial argument, but that is addressed in our brief regarding as a secondary issue that legally is insufficient as well under the statute of frauds. Mr. Whalen, however, misrepresented the membership interest and purchase agreement, and this touches again on your questions of me earlier. The company was not insolvent and subject to bankruptcy or other similar proceedings, conjunctive. Regardless, the evidence in the record is that it wasn't insolvent, even though it had a ton of debt. The company continued to operate. It never went into bankruptcy. But ultimately, Mr. Rickel did not and could not rely upon that. He was provided with all of the financials, and he saw the ever-increasing debt, including debt to Mr. Foulard, and also everything was growing over this time. The liabilities were growing, the debt was growing. The debt to that's addressed in page 6 and 7 of our brief. So overall, the totality of the circumstances show exactly what we argued at trial, and what the court really didn't even address is that this man knew that he was gambling, and he was betting on something, hoping that he would steal the equity and make a killing on it. Nothing was hidden from him. Nothing was misrepresented.
Thank you, Mr. Rentron. Mr. Merrill? And you've reserved 2 minutes also.
Yes, Your Honor. I have a note at the top of my outline to tell me to slow down because I have court reporters across the state who are mad at me, but I've got 2 minutes, so I'm going to go really fast. Justice Landau, you asked for questions about the voting. Plaintiff's Exhibit 24, which is Reporter's Record, Volume 10B, and it's page 53 of the PDF, if that helps. That actually identifies first the votes so far. Alan Davis, yes. Dinah Rock, yes. Mike Foulard, blank. Shelby Beard, yes. Georgia Foulard, yes. Mr. Davis did testify that he thought Mike voted. Mike said he did not. The documentary evidence shows that he did not. Voting, however, is a red herring. It was undisputed by every witness, including by Mr. Rickel, who was asked to go through and look at the membership interests and how everybody voted. This sale was going through with or without Mike, and Mike's vote did not matter. We do not say that this is about unilateral control. That's never been our claim here. What the case law asks, though, is if Mike was in a position to prevent the primary violation. There's no evidence he could, because there's no evidence he was even aware of a primary violation, much less that he had any control over this specific transaction. So what we hear instead is a recasting. Well, this is really about the process. Well, no, the statute actually asks if he had the ability to control this specific transaction. Not a single person testified that Mike, if he had stood up and said this is a bad idea, that anybody would have changed their vote. That would have been an easy question to ask about anybody who wanted to try and get Mike liable, but they didn't ask it. The emails that were sent to Mike, we want to talk about abdication here. There's nothing to ignore because there's nothing that he was told. The emails to Mike do not say anything about what Mr. Rickles was told, only that Mr. Rickles wanted to invest, which is why Mike had to go ask his estranged son, how am I supposed to vote? I don't know anything about this. It is not our burden to prove that Mike disagreed on substantive terms. The only evidence is he didn't know them. And what they're essentially imposing on us is a duty of omniscience, where you have a person who is actively excluded from emails and meetings and doesn't even know these emails and meetings have happened. All of a sudden, it has to control and stop this transaction. There's no evidence. Thank you for your time. We ask that the court reverse the judgment against Mike and render judgment in his favor on all claims.
Thank you, Mr. Merrill. The case of Alan Davis, John Mahoney, Mahoney Group LLC, and Michael Foulard versus MSR Holding LLC and Merrick Medical Finance LLC has been submitted. Thank you very much for your arguments.
All right.